We are good to go.
So, hello, good morning to everybody who is in Agustina and Edgardo's and my time zone, and well, good afternoon to all of you who are on Tatiana's time zone. It is such an honor to moderate this panel of such skilled professionals. I actually had the opportunity to share a classroom both with Agustina and Edgardo back in the day when we were both, the three of us were studying at Berkeley. And I just recently met Tatiana, and oh, I wish we had shared a classroom. I actually love this phrase from her bio, which says "law as a rule of the game." I think it's very linked to her sports law practice, and she will talk about it a little bit more later. Before fully presenting our speakers for today, I would like first to thank Berkeley Global Society for this space to share and connect. Special thanks to Obin, Hema Modi, and Cas Fernandez, who were very helpful in this process of organizing this event. So now I would like to start by briefly introducing Tatiana Vassin. Tatiana Vassin is a French lawyer located in Paris, specialized in business law and sports law. She advises and defends federations, clubs, and athletes, agents, and sports actors in France and all over the world. She also works with national and international organizations such as the European Council deputies, amongst others. And she participates in conferences and world groups dedicated to sports. For example, Animation of International Convention of Maclean, organized by the European Council, Etiquette Sports Conference, organized by French Football Federation, and others. She has a sports law master director at, and I'm probably gonna pronounce this wrong, but the Institut Supérieur du Droit in Paris. She has published several books and acts as a director of Le Milieu du Droit Books Collection, which is a series of innovating and pedagogical books dedicated to facilitate law learning and access to law by stimulating critical thinking as a memorization process. This sounds amazing, actually. She is co-responsible of Paris Bar's Commission, dedicated to new law work fields in sports. Now, I will turn to introduce Augustine Londono. Augustine Londono is a partner at Londono Arango, a boutique firm from Medellin, Colombia. In the firm, Augustine advises and represents insurance companies, financial institutions, construction infrastructure, as well as the gas and oil industry companies in arbitration proceedings and complex litigation. He's an arbitration of the Arbitration Center of the Medellin Chamber of Commerce and a professor of liability at the University of Medellin, Colombia. And now, last but not least, I would like to introduce Edgardo Muñoz. Edgardo Muñoz has a Doctor of Laws, summa cum laude, at Basel University in Switzerland. Obviously, he has the LLM at Berkeley, where we met, an LLM at the University of Liverpool, and he's currently a law professor at Panamericana University. Before joining, Dr. Edgardo Muñoz spent several years working in Switzerland at the Arbitration and Sports Law Group of a leading law firm, as well as at the Global Sales Law Project led by worldwide renowned expert in international contracts, Professor Ingeborg Schwenzer. Dr. Edgardo Muñoz also held research associate positions at the Graduate Institute of International and Development Studies in Geneva and at the University of Lausanne Law Faculty. He also has been visiting scholar at Columbia University Law School in New York, the Law School of the Universities of McGill and Montreal in Canada. So as you can see, we have an amazing set of speakers for today, and I'm very happy to be able to listen to their presentations in a few minutes. So that being said, I will leave the floor to Agustin, who will share with us on the issues of non-signatory parties and award enforcement in Colombia. So Agustin, the floor is yours.
Thank you very much. Good morning, everybody. I want to thank Berkeley Global Society for the invitation and Veronica Esquivel as well. For me, it's a pleasure being here with you guys. As Veronica said, I'm going to talk about award enforcement in Colombia, and if I have enough time, I will talk as well about joining parties that are not party to an arbitration agreement to the arbitration proceedings. First of all, I want to make a small introduction about our arbitration law. In Colombia, we have a law which is known as the Arbitration Statute. The Arbitration Statute has been in force since 2012 and is divided in different sections. One section regarding the domestic arbitration and the other section regarding international arbitration. The international arbitration section of our statute adopted the ancestral model law. Nonetheless, there are some differences with the model law. Probably you are very familiar with the model law, so I'm not going to talk about it. So let's start talking a little bit about award enforcement in Colombia. In Colombia, the parties can challenge the award through the annulment action. There is no right to appeal. So I am going to talk about the annulment action in domestic as well as international arbitration according to our statute. And I will tell you about a recent decision that annulled an award rendered in an international arbitration case, which was like very important, very commented in our country. So the first thing is that in domestic arbitration here in Colombia, the annulment action proceeds only on the grounds of procedural irregularities. We have a list of procedural irregularities in which parties can challenge the award. It's quite a long list. I'm going to tell you like a little bit of grounds, which are, for example, the non-existence or nullity of the arbitration agreement, the application of the statute of limitations, the lack of jurisdiction or competence, that the tribunal was not legally constituted, so and so on. But now what I'm really want to talk to you is about the annulment action in international arbitration according to our statute. And in international arbitration, according to our statute in Colombia, the judicial authority may annul an award at request in the following grounds, which, as you are going to notice, are the same grounds regulated in Article 5 of the New York Convention. So an award can be annulled by request of the party on the following grounds. First, if the arbitration agreement is invalid according to the applicable law. Second, if the party was not duly notified of the appointment of an arbitrator of the initiation of the arbitration action was unable for any other reason to assert its rights. The third ground is that the award deals with a dispute not contemplated in the arbitration agreement, or contains decisions that exceeds the term of the arbitration agreement. A fourth ground is that the composition of the tribunal or the arbitration procedure did not conform to the agreement between the parties. This is a very special ground, and I'm going to talk to you a little bit more about it later. And the award may be annulled as well if, according to the Colombian law, the object of the controversy is not subject to arbitration. That means if the controversy cannot be settled by the parties. And finally, the award award may be annulled when it is contrary to our international public policy. So we have a special rule, and it says that when none of the parties has their domicile or residence in Colombia, the parties may, by express declaration in the arbitration agreement or by written agreement completely exclude the annulment action or limit it to one or more grounds stated in the arbitration statute. I have to say that so far I have not known an agreement in that sense, but it could be like very, very interesting. Here, the annulment action will only proceed against the award for the reasons strictly established in our statute. And the judicial authority, when resolving or deciding the annulment action, will not rule on the merits of the controversy, nor will it qualify the criteria or probative evaluations set forth by the arbitral tribunal. And finally, an award can be enforced when the annulment proceedings are ongoing. So so far, there is nothing like new, and as you saw, like the grounds are the same as they stated in the Article 5 of the New York Convention, which I am sure you are very familiar with. But this year, we have like a very known decision in which an award rendered in an international arbitration was annulled. It was a decision that was very commented and generated like a lot of controversies. I am not going to give you many details of the case because it would take a lot of time, but to put you in context, a Colombian company signed a construction contract with a Chinese consortium. The Chinese consortium was aimed to build a thermal power plant, and during the execution of the contract, the Colombian company alleged several breaches of the contract from the Chinese consortium, imposed fines and charged penalties. The Chinese consortium filed an arbitration lawsuit against the Colombian company, and the tribunal partially granted the consortium claims. Once the tribunal granted the consortium claims, the Colombian company filed the annulment action, alleging that the arbitration procedure did not conform to the agreement between the parties. The disagreement of the Colombian company was based on the decision of the tribunal related to evidence degree. In essence, the Colombian company said that greater evidentiary opportunities were given to the Chinese consortium. After the court analyzed the procedure, concluded that the tribunal denied the possibility of the Colombian company to contradict an expertise provided by the Chinese consortium and allowed the consortium to present a new expertise. The court found that arbitrators misinterpreted the will of the parties, especially that the agreed procedure, as the arbitrators allowed the consortium to have two additional evidentiary opportunities with respect to the Colombian companies. Ignorance of the agreed procedural, according to our court, is enough reason to annul the award without being it appropriate to inquire about the incidence of this irregularity in the decision adopted in the award. According to our court, or the understanding that arbitrators can modify the procedural rules agreed upon by the parties at their discretion affects their rights. Arbitral tribunals must strictly comply with the agreed procedural rules, and the court finally says that when the arbitrators are unaware of these procedural parameters, they also violate the agreement or wills, and therefore the private autonomy of the parties. In the case of the annulment, the extraordinary judge said the court is prohibited from ruling on the decision on the merits of the process. Additionally, in this case, determining the incidence of the evidence in the award or the incidence of the procedural mistake in the award would imply examining the merits of the decision adopted. And according to the court in the Colombian case, it is not necessary to prove that the ignorance of the agreed procedural rules had an impact on or consequences in the final award. So that was the decision of the court, but there was a dissenting opinion with which I personally agree. The dissenting judge basically said that as long as it is a contract which states the procedural rules, the breach of those procedural rules agreed by the parties must substantially affect the dispute. That is, it must have an impact on the way in which arbitration award is produced. The annulment judge, according to the dissenting opinion, when evaluating the incidence of the omitted evidence or the procedural mistake, does not decide the controversy, does not merit on the rules. The annulment judge has to verify what is the relevance of the breach of those procedural rules agreed by the parties in the decision contained in the award, and if it has the possibility of altering it. So the internal procedural law is designed to guarantee the effectiveness of the substantial law so that defects without incidents in the decision are not taken into account when resolving a conflict. In this task, according to the dissenting opinion, the judge of annulment appeal had to determine whether the decision of the arbitral tribunal will not imply of not applying the agreed procedure affected the very object of the contract by preventing the arbitrators from deciding the dispute in accordance with was agreed upon by the parties. So in conclusion, in our court annulled a decision, an award with a very formalistic analysis saying that because the tribunal did not follow the procedural rules accorded by the parties, it was enough in order to annul the decision, even though it doesn't have any effect on the merits. My opinion is that, of course, I believe that procedural rules have a very, very big importance, and it warrants the rights of the parties, but we have to have in mind that the procedural law is designed to guarantee the effectiveness of the substantial law. So I have to admit that I have a worry if our court is going to keep that to keep that concept and is going to continue annulling awards only because the tribunal did not follow strictly a procedural rule. And when the procedural rules are set in a contract, it means that the tribunal has to interpret these rules, and in this interpretation they can come to a different conclusion as the court. So when interpreting the contract, the tribunal may arrive to a different conclusion, and if this conclusion does not affect the decision of the award or the decision contained in the award, I believe that the award should not be annulled. So we have like here an uncertainty what's going to happen in our future, and I hope that in the future the lawyers and the international companies that signed contracts stipulating arbitration agreements in Colombia don't feel like afraid of putting or including them in the contracts, thinking that possibly the award is going to be annulled by a very simple or a procedural a procedural interpretation of the tribunal. So hope this thing doesn't happen again. I also wanted to talk to you about third parties or non-signatory parties, but I think it will take more time. So, Vero, thank you very much. And if there is any question from you, from other people, I will be happy to answer it.
I'm pretty sure there will be a question coming up on this subject, especially because I think it's very interesting hearing from at least what you talked about the enforcement of awards and annulment of awards in Colombia. I think this perspective will also be required from you further in this conference on non-signatory parties. But to go on, I will now introduce Edgardo, who will talk to us of some of his ADR experiences in 2020 and also a recent decision in Mexico on award authentication. So, Edgardo, the floor is yours.
Thank you, Veronica. It's a pleasure to be here with the Berkeley Law Global Society. Berkeley Global Society, I think, is a correct name. But I feel very privileged to also share this panel and discuss with my esteemed colleagues, Augustine Londono and Tatiana Bassin from Colombia and France. So I think I'm going to start with the last topic, which is this very recent decision by Mexican Supreme Court on the requirement to authenticate an arbitral award. I will give a bit of context because it's a very welcome decision by the Mexican community, and I think it's also a good sign on how Mexico is a pro-arbitration seat, and that explains also the big number of arbitration that have been going on in the country in the last years. So Mexico also adopted the model law, but its adoption was prior to the 2006 amendment. So the version that Mexico has is the 1985. So in this version of the model law, if you recall Article 35, second paragraph, it states that the party who wants to pursue the recognition of an arbitral award must provide the award duly authenticated or a certified copy. I think that's the correct wording. I'm gonna check it right now. I just checked it before, but yes, that's it. Is shall supply the duly authenticated original award or a duly certified copy thereof. That is the text of the Mexican law, arbitration law, but in Spanish, which basically is the same. It uses the same word, authenticación. So in the last decades, there was some discussion, and actually there were a couple of decisions by collegiate tribunals, which are the second instance in, actually, yes, the second instance in what would be a recognition proceeding, but they only work as courts that verify compliance with the Mexican Constitution. And one of them said, well, this requirement, it interpreted this requirement softly, saying authenticated doesn't really mean going through a Mexican notary and verify that the signatures are from the people who claims to be signed. And a different court said, no, it actually means that party seeking the recognition of an arbitral award must provide an authenticated award in the understanding of the notary public law requirement. So this case that was decided last month was a good opportunity to clarify that matter, and actually came with a decision that was a bit unexpected because it did not bend towards an interpretation, but it basically said that requirement is unconstitutional. We do not need in Mexico the authentication of an arbitral award, neither on the understanding of Mexican law, nor in the understanding of the Hague Convention, on authentication. It is enough that a party provides the original award or a certified copy. And what is the context of this case, which is also very curious? In the final decision published, we don't know the context, they deleted, but in the draft that was submitted in advance by the justice that prepared this decision, we know that this was a case which sit in London. And curiously, the award was an award by consent. It means that the party were in agreement with what would be the result of their disputes. They made this transaction, this agreement, and asked the arbitral tribunal to elevate it, to give him the category of an arbitral award. As you know, this is possible under most law. So they didn't challenge the award in London. Perhaps it would be too expensive. I don't know why. But what one of the parties did is to wait until the enforcement proceeding in Mexico. And while it was being enforced, it claimed that the other party had not provided the authenticated arbitral award and therefore was not complying with what would be the equivalent of Article 35(2) of the model law in Mexico. And either under the New York Convention, you remember also that Article 2 provides exactly the same requirement. So the Collegiate Tribunal, which is the one who would know of these cases, decided in favor of flexibility. It said that requirement actually does not comply with what would be our constitutional values, because it's adding something to the recognition and enforcement of the award that would diminish flexibility and efficiency in the enforcement. And so the case was taken also later on by the Supreme Court, and the Supreme Court did a rather good analysis, I think. The reasons for the Supreme Court in upholding what was a decision of the Collegiate Tribunal was that indeed, we had that requirement. It came from the 1985 version of the model law. It was also under the New York Convention. However, it said, the travaux préparatoires, if I may say, the working works of the UNCITRAL model law stated that in terms of recognition, each state may be able to state or to establish their own process, and that the requirements there were only the maximum, but a state could actually lower the standards. And it was also the case in the New York Convention, because under Article 7, the principle of the most favorable law, or favorable law. There is obviously some requirements under the New York Convention, but a party may claim other requirements that are more favorable in order to enforce an award. And that was what was the reasoning of our court. It said, actually, in 2006, the model law changed, and Supreme deleted that part, and it only wants a copy afterwards. Only requires a copy afterwards. It shows that arbitration is evolving towards more flexibility, and a party cannot take a stand or prevail in an enforcement proceeding only because of that formality, it said. If the party is actually challenging the authenticity, it has to say so. It has to say that award was not signed, but it's not the authorship of the arbitrators. But it cannot rely merely on a formalistic requirement in our law to refuse or to prevent the enforcement of the award. And as you can see, is a very good decision for all people that is in this community, in this topic. And I just said that, but I will briefly also touch upon my experience this year. I have 2 cases as an arbitrator and 1 as counsel. And as counsel, I had the experience of having the virtual hearings. I think it was a very good experience. The arbitration pushed for it. Me and my co-counsel on the other side wanted an in-person hearing because although it had a lot of elements and was administered in Paris, the arbitration, most of the people involved was in the country, actually in the city, except for the arbitrator, which was in a different Mexican city. But the arbitrator, after hearing our proposal for an in-person hearing, said that she did not actually believe it was necessary, and both of us, counsel and parties, decided to go ahead with the virtual hearing, which was a huge success. And I think there are many things we can take from what happened this year in terms of virtual hearings in arbitration, reducing costs, reducing the ecological environment impact, right? And so I was happy to experience that. On the other side, as an arbitrator, I have 2 curious cases. One arbitration, before the pandemic, the parties had decided to suspend it, to try to negotiate an agreement, an agreement or a solution on this case, on their case. And then the pandemic came out. We, as the arbitrators, the tribunal, asked them whether they had enough time, what was the status of their discussions, and they said that they couldn't find any agreement so far, but that they said they wanted to take the opportunity to suspend the proceedings indefinitely, given the fact that the pandemic had impact both the commercial activities and legal activities of the people involved. So it was not until recently that the pandemic started to lower down in some countries, not in Mexico, that they decided that we issue a new order to start the proceedings again, to reinitiate. In the other arbitration, when I am a sole arbitrator, this is a curious one, and actually is related to what Agustin was mentioning. I had a claimant who did not pay the advance on cost and couldn't pay after some months. And his argument was that he couldn't do it because of the pandemic, banks, issues, etc. In this particular case, the defendant, the respondent, had paid the advance, and it was a mistake of the institution that did not realize that the claimant hadn't. So the respondent was pushing for set a time limit, otherwise the claims should be withdrawn. That's what the rules said. Set a time, the court set a time, the institution set a time, claimant failed again, the institution set a new time, it failed, and according to the rules that would be it, the claims would be considered withdrawn. Next day, claimant paid. And the institution was called to decide whether it should consider that the claims were withdrawn or whether the arbitration should continue. And it decided that the arbitration should continue. I guess this touches upon what was the agreement of the parties under the rules. Can we really go ahead and with no impact in the future award? well, the arbitration is ongoing. I cannot say, and I didn't take that decision. It was the institution, so and my hands are clean, right? But that's it. And for next year, I didn't have any sports cases this year, but I'm very eager for next year because I was recently appointed as a member of the appeal tribunal of the International Gymnastics Federation, and so I hope I will have cases on the sports law, at least in the internal ADR proceedings for the Gymnastics Federation, International Federation, precisely because, as you know, in the last couple of years we have heard a lot of from athletes in that discipline. So thank you, Veronica.
Thank you, Edgardo. I already saw Tatiana getting excited on the sports issues you've mentioned. And totally, for all of you that have not guessed, Edgardo and myself are both from Mexico. So just following up, definitely this decision he discussed was received very eagerly by all Mexican lawyers. It was a very good decision. It comes to reinforce how Mexico is a pro-arbitration seat. And we were very excited to hear it or have it decided in this way. But without further ado, I will now leave the floor to Tatiana so she can enlighten us with her experience. I believe she will be sharing a few words on the CAS, arbitration of the Court of Arbitration for Sport, and a bit on the limited impact of COVID, and finally the 2020 focus on consequences induced by a specific recent case. So Tatiana, the floor is yours.
Thank you, Veronica, and thanks for the invitation. I'm very happy to be there with you. And I would have preferred to be physically with you, but I think it's difficult today to be physically present anywhere. So I'm glad to be there in an electronic video conference. So thank you again. And I am very glad also to speak about a very specific field of arbitration, which is the sports arbitration. Arbitration has a very huge place in sports issues. We have the Court of Arbitration for Sports, which is a very, very big institution which was created to resolve sports-related disputes through arbitration and also mediation. So just let me say, please, a few words about this institution. It has 3 divisions, one ordinary division, arbitration division, another division which is an anti-doping division, and the 3rd division which is an appeals arbitration division. So 3 divisions which judge every type of cases, and which is very, very important because we have some regulations in Sports International Federation, which provides the recourse to a CAS in order to solve the majority of issues in sports. So its role is very, very important in sports area. Concerning this year, I think for the CAS it was the same issues as Edgardo discussed. The impact of COVID was limited because even if the impact in the sports area was very important with some postponement or suspension of major competitions such as Tokyo Olympic Games or the UEFA Euro. The organization of CAS was also very efficient to be able to treat different issues, even if there was no physical hearings. The CAS decided to take some emergency guidelines in order to adapt itself to the difficulty caused by the COVID and to facilitate the access to CAS by using the CAS filling platform and by holding hearings by video conference. it was not really a huge challenge because we already worked in electronical way with the CAS, with some statements, some brief appeal, some statement of appeal, which were already sent by email. So it was not a big adaptation for us as lawyers. The CAS procedures have not been delayed, except when parties have chosen to postpone their hearings in order to hold it in person. But the impact was very limited from this point of view. I think the major impact for the CAS was that the COVID pandemic postponed the renovation work of the CAS headquarters, because the CAS is willing to move out and to go to the Palais of Beaulieu at Lausanne in Switzerland. And the construction work was delayed about 6 weeks, so that the CAS won't have its new headquarters before November 2021. So I think it was a major issue. It's not very important for us as a sports lawyer, and I think it's good this way. So another thing that I wanted to share with my Spanish friends and Spanish colleagues is that since the beginning of July 2020, Spanish has been recognized as the third official language for CAS arbitration. So that if you want to come, you're welcome in Switzerland, but you are also welcome to plead in Spanish if you want to do so. So here's the good news. Concerning the CAS activity, I wanted to speak to you about something new which happened this year and which is not related with the pandemic, which is a public hearing. It's a resultant of a case, which is a Pechstein case, because the CAS code has been modified. Its article R57 now provides that at the request of a physical person who is party to the proceedings, a public hearing should be held if the matter is of a disciplinary nature. You have some exceptions related to morals or public order, national security, minors when there are minors in a case in order to protect their private life. So you have some exception, but you have now a principle, which is a principle of public hearing when you want to have one as an athlete. And it was something very new, which comes from the European Court, because Mrs. Pechstein, who is a professional speed skater and was suspended 2 years for anti-doping rules violation, asked for a public hearing when she came before CAS. That request was denied, and she challenged the award of the CAS before first the Swiss Federal Court, which denied also that request, and she decided then to challenge it before the European Court and to ask for a public hearing, a right to a public hearing. The European Court has a very big influence on the award of the CAS, because it has to sometimes to review some of them, also in a very specific field, because it's also about public order and valuation of very specific points of the European Convention. And this one was important because it was the Article 6.1 of the European Convention, which provides the right to a fair trial and a public hearing. So the question was to decide whether the claimant could have a public hearing or could not, because the principle was really to have a private station. And finally, the European Court decided that according to the Article 6.1 of the European Convention, it was the right of the claimant to request for a public hearing. And it is very, very important because it was not the principle. It's almost it is a fundamental principle which is enshrined in Article 6.1 of the Convention, but it was not a principle which was applicable in sports arbitration. So it's a big, it's something very, very big, very new. And now we have the first hearing, the first public hearing, which was held before CAST in 2020, also in anti-doping rule matters, and it was really a first case, and I think it was from this point of view a success, and I think it's also a big it's something we must encourage, because as it is said in the Article 6.1 of the European Convention, it is a guarantee also for a fair justice, so that when you have a matter concerning disciplinary issues which are usually held before international federation, and which has a really big impact on the career and the life of an athlete, I think it's important for each of them to have the guarantees of fair justice. So it is now the case with the possibility to have public hearing. I think we will have other decision coming from European Convention concerning the CAS and the proceedings before CAS, because the CAS proceedings are regularly challenged before European courts. It is the case for the criticals concerning the independence and the impartiality of the CAS, which was regularly challenged, which were challenged by Mrs. Pechstein, but she was her request was dismissed on this point, even if she got two dissident opinions from the judges, who considered that there were independence and impartiality issues concerning the arbitrators of the CAS who are nominated by the CAS. So you have a list of arbitrators who are chosen by the CAS, and when you have to go before the CAS, you have to choose only in this list. These arbitrators are recommended by sports, mostly by sports national organization. So it could be there could be some inequity between athletes and sports national organization. So I think these issues are going on. We will have new issues in the next year, but here is one that I wanted to share with you.
Thank you so much, Tatiana, for your presentation, and actually thank the three of you for your amazing presentations. I would like now to move to questions. I don't know if you want to first, I don't know if any of the three of you have questions for your other panelists or co-panelists, or if you want me to go directly to the questions from our attendees.
We go first to the attendees. Questions.
Actually, we have here a question, and it's exactly for you, Edgardo. So it's briefly, what are the requirements for a translation of an award in Mexico when seeking recognition and enforcement thereof?
Is it must be, basically the requirement is that it must be translated by an official translator or authorized translator. And each court, depending on where you are seeking enforcement, has a list of certified translators into different languages. So he would usually do the translation, put the seal, stamp it, and that's it.
Thank you, Edgardo. And well, I don't know if any one of you want to jump in. Otherwise, I would like just to make a brief comment. I don't know if Agustin, Tatiana, Edgardo, you have a question for any of your co-panelists?
I wanted to know from Agustin if in that particular case, whether it's known or not, the party who considered that the other party had 2 extra chances to provide an expertise stated so, raised its hand before the tribunal as well. And what was the consideration of the tribunal?
Yes, they did, and the consideration of the tribunal was what they did is they interpreted the procedural rules set by the parties in the contract, and their understanding was that they were following the procedural rules set by the parties. So they raised their hand as you said. And I also have to clarify that in order to try this annulment action based on the ground that I mentioned, is not necessary to raise the hand during the arbitration process.
Thank you, Tatiana. I don't know if you have anything to add.
Maybe just a remark, because we spoke about enforcement, and I think even if the sports system has some difficulties, maybe, I think it's a great system for avoiding problematics related to enforcement, because it is provided by international federation that when you have a CAS award, international federation have to, let me say, enforce the award. So you don't have to go through national courts. You have to go before your international federation and to ask for eventually a disciplinary sanction if the award is not respected by the other party. And as, for example, in football, the FIFA has an international scope, FIFA can ask for the application of the award to each actor of the world of football. So even when you're in France, in Mexico, or in Spain, or wherever you are, it's not really important, because FIFA has the legitimacy to make you respect its decision and its will. So I think it's something which is important in sports law area, because I know the enforcement is very difficult sometimes, but in this field we have the chance, if we can say that like that, to have the support of international federation who helps party to make the award applicable.
Thank you, Tatiana. I don't know, last chance for any of you to speak, or I'm gonna wrap it up. So if you wanna take advantage of.
I just wanna say that the reflection made by Tatiana is tricky sometimes, because indeed federations had a big power. So usually when the athlete is the loser, there is no way that the athlete cannot follow the decision, because the federation, international or national, would not allow him to compete. And sometimes they have gone, sometimes, this is a big criticism, but sometimes I had I represented a party against an international federation in a commercial matter. So it was the ordinary division of the CAS. It was basically my city against FINA. I can say this because this is public. FINA is the swimming federation. And this was a commercial matter, totally commercial. But what did the federation to put a bit of pressure on the city and the country was to penalize athletes from Mexico. And we had, I mean, I was not in that case, but Mexico filed a different appeal because, I mean, it was totally grown. I think that for a commercial matter, you would use your federation power to affect the athletes. It's just a reflection of the world of sports.
Yeah, I think you're right. I think it's also curious. It's one of the curiosity. We already spoke of some curiosity in arbitration, but we have also some curiosities in sports law area. So yes, I agree with you. It's difficult for the athletes, and it's almost the athletes who criticize the CAS function and the CAS organization because they think it's not independent sometimes or impartial. But I think if we take the example of the football, it's interesting because when you are the lawyer, for example, of a footballer, and that you're in a case where the footballer is not paid, you have the faculty to ask for before the FIFA to make the award applicable, and the FIFA can tell the club that the club has to pay even if the club doesn't want to pay the footballer. So it's very interesting. And on the other side, I think that it's maybe sometimes more difficult for clubs who are claiming maybe money before for some players, because the players, if he's maybe 30 or 32 years old, some players decide to disappear, and the FIFA cannot do anything because they are not in the sports area field, which is not the case of the club. So for that kind of matters, we have to go through the enforcement, and it is more difficult. But we have some advantages. We have some difficulties also before CAS and with international federation, and I think we have some improvements to make in order to make the justice fair. But I think it's a beginning. But I agree with you. We should not take the athletes in hostage, and I think it's even more real today. Today we have a new award from the CAS, which was made public concerning the decision against Russia, and the fact that Russia would be excluded for the next 2 Olympic Games. So it's a very big decision with consequences very important concerning athletes. So I think it's something we have to think about. How can the sport justice be fair, but for each actor of sports, and be protective concerning the athletes, which are maybe the most fragile public of the sports area. So maybe we will arrive to make things evolve. That's great lawyers. I think everything is possible.
Thank you, Tatiana and Edgardo. This is such an interesting topic, and well, I'm going to invite our attendees today to follow BGS on social media, because I'm pretty sure soon they'll be announcing a further event on sports law. I think it's a very interesting topic, and if I allowed Edgardo and Tatiana, they could speak about this for a whole lot more hours. So follow BGS to be in tune on the next events. I'm pretty sure there'll be a sports law event upcoming. So I would just like now to thank once again our three panelists for such amazing presentations, BGS for hosting this event, and obviously I always like to thank the attendees of this session, because obviously this would not be worthwhile if we didn't have you, your questions, your participation, and especially in a subject such as ADR. I believe ADR is currently in the spotlight in many countries that were more litigation oriented in the past, especially due to the COVID situation, courts closing, a huge backlog in courts. And I like the fact that Agustin discussed the dissenting opinion on the flexibility. Even though there's a decision, there was this dissenting opinion, which I think is very valuable. I think Edgardo discussing virtual hearings in his experience this 2020 was very relevant. And obviously Tatiana discussing the limited effects COVID had. I think this goes on to show the relevance of ADR, not only arbitration, mediation, negotiation, all other ADR mechanisms which are available to parties, especially in this difficult time. So thank you for joining. Have a great day, everybody, and we'll see you soon in an upcoming